InnoTalks is an informative venture of InnoSec, a subsidiary of Microsoft Technologies InfoPark. We will be bringing in industry experts to share their experience and thoughts. This will be an excellent opportunity or experience for your business and career. Stay tuned for more videos.
If you look at the privacy policy of Facebook and all, what they can do with the photographs or contents that we post is nobody will actually go ahead and post anything on Facebook.
Today in InnoTalk, we have Advocate Anith James, partner of Brands & Bonds, a fully fledged legal firm. His major area is IT laws in India. So today he is going to share with us his perspective on IT laws in India. Welcome, sir. Okay. So coming to a major question,
Yes.
Which is something like currently almost all business segments have their online presence through a website or through a mobile application or something. So in every website and mobile app, there will be a terms and conditions area, which we usually ignore. Not really.
Okay.
So how important or what is that terms and conditions exactly?
See, terms and conditions is basically the rules or regulations you have to obey once you are using a particular website. That is, if you have an interactive website more specifically. These are the terms and conditions or the rules and regulations which a user have to obey when you actually use the website. Right? And the importance is, to give you an example, you can have a disclaimer on that. If you own a particular website, you can have a disclaimer on that, and you can have other rules and regulations like if it is an interactive website, you can actually restrict the person on as to what kind of things he can upload to that. These are the basic things.
Okay, so what are the types of websites that need this?
See, mostly terms and conditions are very important for an interactive website, and the exceptions are like if you say if it is an informative website. For example, if it's a website which contains a blog, and you are aware that a lot of people are actually relying on that information that you provide, so you definitely would require to place a disclaimer stating that. Yes, stating that please, do not rely on this information, and I am not responsible, or this website is not responsible if you rely on this information and you incur some loss or damages or whatever.
So what about this thing on a website like Facebook? So,
yes.
So how you play this thing for that?
See, Facebook, it is more of a social networking website.
Okay.
So in Facebook, it is more the users are actually, the contents are actually inputted by the users. The users are the ones who creates the content. So definitely you need to have a regulation as to what sort of contents you can actually upload, the types of photos, the types of comment. You are not supposed to, have any vulgar pictures or any comments which actually hurts the sentiments of a particular community or religion. So you need to ensure that these rules are present on your website so that the users are more aware and they stop, or stop from uploading such comments or pictures.
So we have been seeing privacy policies for many websites and mobile apps. So is that a mandatory thing?
See, again, it depends on if it's an interactive website or if it is a mere website which showcases your business, then privacy policy is not required. But if your website, if it so much as has a cookie which gets some information from the user, then it is mandatory that you have to put a privacy policy. So to get more on, say more on privacy policy, it should essentially state a few things. Like first, what are the data that you are collecting from a user?
So you mean you're now mentioning about the things which need to be included in the privacy policy?
Yes. What are the type of data that you are collecting? Second is why and for what purpose are you collecting it? Third is once you collect the data, what are you going to use it for? Right? And the fourth is how are you going to store that data? Because the user will be concerned, because in some cases you probably might have to get the user's personal information. So the user will be concerned and he has got a right to know what are you doing with the data and how are you storing it, how secure is your storage mechanism. Because the user doesn't, nobody likes his private information to be leaked out. So if you are collecting it, you need to store it properly, and every user has got a right to know how he is storing it.
So I have heard about some terminologies like terms and conditions, TOS, EU, LA and all. So what are they exactly? So are they same or?
See, the terminology may be different, but the contents essentially is the same. But again, it's like for different situations you use a different terminology. For example, terms and conditions. It essentially means what it says. Terms and conditions for a website or for a particular contract. If you're contracting with a person, another person, these are the terms and conditions which both parties have to abide with, comply with. That is terms and conditions. Then TOS is terms of service. Which is essentially, if you're providing a service, be it online or offline, these are the terms of service. If you are coming to me for availing a service, these are the terms. So it is more applicable for if you provide service through online, like SAS, software as a service, or any online services if you provide, you have a TOS. EULA is slightly different. It's actually a contract between, an agreement between the person who purchases the software and the vendor of the software. EULA means end user license agreement, or it's a license basically. So if I'm selling you a software, a product, it's actually I'm giving you a license to use that. So it is end user license agreement. It is more commonly it's in a click wrap form, where online EULA is once for example, if you use Windows, you see that agreement. And then all you need to do is click I agree or OK.
Which we usually
yes, it will seal the contract. Yes. Normally people do ignore that, but those are the terms and conditions when you purchase a software and you get a license.
So really, what is the position of data protection and privacy in India in comparing to countries like USA, UK, etc. like that?
See, privacy and data protection for a personal information. Personal information means any information which can identify an individual, right? Like your name, your date of birth, etc. So protection of personal information or that personal data is very important. And to compare with other jurisdictions, I would say Europe is much more advanced in that. The rules are more stringent in Europe, European Union, than USA. India, it's a very nascent stage, and you are really that privacy law is only developing in India. In Europe, you have the European Union guidelines, EU guidelines, which has got certain restrictions. These restrictions, unless and until these conditions are met, you cannot actually collect any personal or private data from an individual. For example, that individual should be aware of what are the personal data that is being collected. Second, he should give his consent, complete, full consent. Third condition is the necessity of the data collection. What is the necessity? Is it necessary for that individual's well-being, or is it necessary to fulfill a legal obligation, a contract, or is it necessary to if the country has got certain issues, something like that, like for example a terrorist investigation or something like that. Unless these conditions are met, you cannot actually collect somebody's personal information. So that is how strict Europe is. And in US, you don't have it's not like a single guideline or a single laws. You have got multiple laws which overlap. For example, FTC, Federal Trade Commission. Then you've got the HIPAA. Then you've got Financial Services Modernization Act. All these combined come forward to the protection of a personal information or private information. So for example, the HIPAA law, that is Health Insurance Portability and Accountability Act, it states that a person's medical information is private information. So you cannot disclose it to. There are certain guidelines. And the Financial Services Modernization Act, it is more relevant for the banking sector. A person's financial, like his credit card and his financial details should not be disclosed. So that is how the US goes. And then you also have certain rules and regulations with regard to your disclosure of electronic communication. So even if the government wants to snoop on your email communication, it has got to comply with certain conditions. Only then, even for security purpose, only then the government can actually snoop into your communications.
You might have seen something between Apple and
Correct. Exactly.
Yeah.
You've seen that Apple has, or the FBI
Yeah.
has to go to court, and even then, Apple has not actually relented
Exactly. Yeah.
to get the information out of an individual's phone, iPhone.
Okay.
That is exactly what it is. And in India, things are relatively very easier.
Okay.
And as such, the protection is given to sensitive information. Sensitive information is, it is actually a form or a part of personal information which is sensitive, like your race,
Okay.
your sexual orientation, your political affiliation, to which political party you have affiliation. These are all sensitive information. There are personal as well as sensitive. So, Section 43A of the IT Act, it clearly states that such information should not be disclosed, and there is a fine.
Okay. If disclosed.
Correct.
Okay.
And in India, you actually get by, and if you want to protect your personal information, it's more of a contractual obligation. Suppose you have a contract with another person, and you clearly mention in your contract that these are confidential information, these are personal information, and you should not be breaching that.
Okay.
And then you can actually protect yourself. And you have section 72, I believe, of IT Act, which actually protects the personal information from being disclosed. That is, if you have a contractual obligation, then they have imposed a fine, like it comes to around 5 lakhs
Oh, okay.
if you disclose.
Disclose.
Yeah.
This kind of.
Yeah, that is how India stands vis-a-vis other jurisdictions.
We can see lots of e-commerce websites these times.
Right.
So if I'm planning to start an e-commerce website or e-commerce kind of business,
Okay.
so what are the things I should keep in mind for starting an e-commerce website?
See, again, e-commerce, the majority are it's more like a commercial website where you sell a service or a product, right? There are different kinds of e-commerce. If you take example of a seller,
Okay.
there are two types. One is you are actually selling your own goods. It can be either B2B or B2C. B2B is business to business, business to customer. You're selling your own goods. For example, if you take case of a retailer having his website and he's selling his goods through that particular website, that is direct one. Then you have indirect one. Big example is Amazon, Flipkart and all. They are not selling their own goods, but they are actually providing a platform or a marketplace where different sellers can actually place their goods in marketplace.
And the delivery will be happening. from
Correct.
segmenting.
Correct. So if it is your own goods, then unfortunately you have to take the entire responsibility. But again, there are certain things which you need to mention: the terms and conditions, the return policy,
Okay.
payment, etc. For the other one, you need to be very clear that what is the responsibility of the seller. You initially have to have an understanding with the seller, a contract.
If you are building something like a platform for others to
Correct.
sell the
The contract or the terms and conditions should clearly state that this is only a platform and we are not selling our own product.
Okay.
And to an extent, you can do away with your liability. But again, for example, if I'm a purchaser and you are a marketplace like Amazon, and I bought something from you, and I found that the particular product does not match my requirements, or it is a fraud, or it's a fake.
Yeah.
So my first action would be to contact you and or bring a case against you.
Exactly. Yeah.
So your rescue comes in wherein you have an agreement with the seller, and you can get the seller to indemnify you.
Okay.
Right. So the point I'm trying to make is, if you clearly state on the terms and conditions that I take no responsibility, this is the seller which is providing you with the goods, this is not my goods, and I'm not taking any sort of responsibility, then nobody will actually come to your site. Because you have to have some sort of a trust, because that is what Amazon, Flipkart and all do. Versus some other less famous marketplace or less famous e-commerce site. Why people choose Amazon and Flipkart? Because you know that if something goes wrong, there is Amazon who will back you up. That's how it goes.
So, is this social networking websites like Facebook and networking apps like WhatsApp, are they really liable for the contents posted by their users?
See, that's a tricky question. It depends, because the IT Act itself has got. I mean, it's clearly stated that intermediaries are ones like Facebook and all, because they are only a platform. They don't create the contents. Us users are the ones who are posting the contents. So, a sort of an immunity is granted to these intermediaries like Facebook, WhatsApp, etc. if certain conditions are met. Because again, if I have to give you an example, like if you are a magazine editor, and a person is actually writing some scandalous article, or he is posting some obscene pictures, or he is writing a scandalous article, who will be held liable? Both the magazine and the person is also, because even though he is the one who is writing, you are the one who is editing, and you are the one who is publishing, right? Same applies to Facebook also. But the conditions are: one, you should be an intermediate. That is, you should only be a platform. Second, you should not have any control over that content. Data. Because in case of Facebook, you have got millions of people uploading. So there is no way Facebook can actually look at each and every post.
Exactly.
They cannot modify. The third condition is you cannot modify or anything. And another condition is they should, these people like Facebook and all, they should actually comply with the guidelines given by the government. So the guidelines, it's like the intermediate guidelines are like, you should clearly state that such things should not be done. For example, pornography should not be posted, or you should not post anything which causes communal hatred. You should not post anything which is anti-India, which is against the sovereignty, integrity of India, the nation. Things like that. That should be clearly mentioned in the terms and conditions. And you should also clearly mention that unless and until the user is completely agreeable to these terms and conditions, please don't use this website.
So
right?
Which means if we can go through the terms and conditions,
yes,
it's something else. We won't be there.
Correct. Yeah. Again, the thing you asked is more relevant for privacy. Privacy. If you look at the privacy policy of Facebook and all, what they can do with the photographs or contents that we post is nobody will actually go ahead and post anything on Facebook.
Is really this terms of use and privacy policies really applicable for mobile applications?
That depends actually, because if for example, if your mobile application is only directing or redirecting to your website, then the terms and conditions and privacy policy of your website itself is sufficient. But if it can stand on its own, and if it is if you have to install it and it is a mobile application by itself, then definitely you have to give the terms and conditions and privacy policy. Because some of the apps, they access your camera, they access your SMS, etc. So we need to clearly mention that these are the data that is being collected by the app, and how are we going to use it, or what are we going to...
So as you mentioned, so this is needed for if you are installing a Facebook application.
Facebook application, I would say that the terms and conditions of the website itself is enough. Or you can put just a small link, wherein once you click that link, you will be redirected to the terms and conditions and privacy policy of Facebook.
So if I made a website, or not a website, an application, a software application, and I'm planning to sell that thing. So can I use a contract that I can get from Google by searching?
You mean download it from the internet?
Exactly.
Yeah, I mean there are lots of thousands of contracts available on the internet, but my advice is don't go for that, because each product is different. The one you find on the internet will be for that specific product, right? Each I don't believe there is a one size fits all kind of template which you can use for all, because again there are different kinds of product which you will have to describe the how it works, and what are the terms and conditions specific for your own product, and are you licensing it, or are you outright selling it with the source code, or if it is a SAS, that is a software as a service, then no licensing or anything is required. You are actually selling the services, so terms of service is required. So I wouldn't recommend downloading it from the internet and just each has to be tailor-made.
So is this electronic signatures valid in India? I've been hearing it for long, so.
Again, that again depends.
Okay.
Because electronic signature, there are, if you look at electronic signature, even if you scroll your signature or your name with a digital pen or a stylus or with a mouse, it can be an electronic signature.
Okay.
So as such, electronic signature might not be valid. But if you look at digital signature, you probably would have heard of digital signature.
Exactly.
That is, it's one form of electronic signature.
Okay.
That is perfectly valid as per the IT Act of India. So digital signature is you actually encrypt that particular, there is an encryption happening there, and it is attached to that particular document. And you have a private key and you have a public key for that. And you give your public key to anybody, the recipient, for example. And that recipient using the public key can actually validate whether you are the one who has signed it, whether there is any tampering involved. Once you have signed it, has that document been modified, etc. But again, this digital signature is used only in government websites and stuff like that. It's not for your normal mode of communication. Our IT Act is provisions for accepting electronic signature, in the sense that there are a lot of service providers who give you electronic signature. But only thing IT Act is mentioned that those service providers or those types of electronic signatures which the central government has notified will be valid in India. Thing is, so far central government has not notified any electronic signature service provider. So as of now, it is not valid.
It's not valid.
Yes.
Can we make a contract with a person in another country, or person or a business in another country? So how can we proceed with that?
I mean, like if I'm sitting here in India and
Exactly.
okay, the best way would be to ask the person to come down to India, sign the contract physically, and then leave. Or you can go to his place of residence and sign it. The other way, the other methods are like you have to take a printout, a hard copy of that contract, sign it, courier it to the other person, get his signature, and once you get it back, you have to get it stamped.
Okay, I understand.
Yeah, that will be the most proper way.
Okay.
Other than that, the IT Act has recognized email communication as evidence. So, if you send it through email and from your registered email to his email ID, and once he says that he's accepted it, it can be treated as a contract. But again, it would be irregular because of the stamping issues and things like that.
Okay. So, do we really need all the contracts to be in a stamp paper to make it valid?
See, unfortunately, yes. Because even though the Indian Contract Act does not specify that, actually the Indian Contract Act says that even oral contracts can be a valid contract. But the Stamp Act, it's more of a regulation. So if it is not stamped, it's an irregularity.
Okay.
So chances are that an unstamped a contract which is not properly stamped might not be recognized in a court.
Okay.
So what you can do is you can impound it by paying 10 times the required amount. For example, if a particular contract has to be on a 200 rupees stamp paper, you have to pay 2,000 rupees, and then if it is not stamped, you have to pay 2,000 rupees and then produce it before the court. That is called impounding.
Okay, that's it. So
Yes.
it should be in a stamp paper. Contract should be in a stamp paper.
Yeah. Even though, like I said earlier, IT Act recognizes emails and stuff like that. But if you have to produce it before a court, it is ideal that it should be stamped. And again, IT Act also states that certain things like a trust document, a will, negotiable instrument like check, promissory note, and all. These are not recognized under IT Act. This should be on a physical paper and stamped.
So imagine if I have a client in Delhi,
Okay.
and I'm operating from Kerala,
Okay.
and a dispute happened between us. So
Okay.
how can we proceed in this?
You mean the
filing
place?
case,
Okay. It again depends on your contract. Your contract will have something called a jurisdiction clause, where you can, under a jurisdiction clause, you can have a exclusive jurisdiction. That is, like, for example, if you are sitting in Kerala and the person is in Delhi, Normally, as per rule, if you want to file a case, then you should actually go and file a case where the other party resides. You become the plaintiff. You are the one who is filing the case, and the other party becomes the defendant.
Okay.
So normally, it is the defendant's place where you have to go and file a case, or where the actual thing took place. Right? The cause of action. It's called cause of action in legal terms.
Okay.
So that where the contract was signed. If it was signed in Kerala, the Kerala courts would have jurisdiction. But again, normally what people do is they restrict or they give exclusive jurisdiction to one place. For example, you can put it in a contract stating that only the courts in Cochin will have jurisdiction.
Okay.
If both parties agree to that, and if there is a dispute with regard to that contract, then the Kochi courts will have the exclusive jurisdiction.
Okay. Right. I hope all have a basic idea or understanding regarding the IT laws in India. So thank you, sir, for joining with us.
My pleasure.
That was Advocate Anith James, partner Branson Bonds, in InnoTalk with his perspective on IT laws in India. Stay tuned for more videos like this. This is Harun Shah Salim signing off.